Very good morning, students. Today we'll be dealing with section 11, Resjudicata under the Civil Procedure Code. Now, while going through this particular topic, that is to say section 11, Resjudicata under Code of Civil Procedure, I wish आप सभी को जो हमने अर्लियर लेक्चर में रेस सबजुडाइज पढ़ा है, सेक्शन 10 पढ़ा है, उसको माइंड में बहुत ही क्लियरली एंड अंडरस्टूड मैनर में बिठा के रखना है. देन वी विल बी इन अ पोजीशन टू डिफरेंशिएट between res subjudice and res judicata. Now, before I go further, I would just like to ask you people that have you ever heard about res judicata, or it is for the first time you are hearing it? You might be hearing it, some of you might be hearing it for the first time, and some of you might have heard it earlier also, because in some of the lecture we would have definitely given an example, but I assure you, you have heard this res judicata, maybe in some different term, and which different term we would be covering in the coming slides. Now, let us start. What do we mean by the term res judicata? Student, res judicata is a rule of giving finality and conclusiveness of judgment. It is nothing but a rule of finality or a conclusiveness of the judgment. Finality is in relation to the points of fact and the law decided earlier. Finality is in relation to what? Finality is in relation to the points of fact and the law which is decided earlier. अब let us understand these two points very clearly. Res judicata एक ऐसा रूल है जो कि फाइनलिटी देता है, कंक्लूसिवनेस देता है किसी भी जजमेंट को. अब फाइनलिटी किसको, कंक्लूसिवनेस ऑफ जजमेंट को तो ठीक है, पर जजमेंट जो है वो कौन से बेसिस पे होता है? तो जजमेंट जो है बेसिकली किस चीज के रिलेशन में दिया जाता है? इन रिलेशन टू पॉइंट्स ऑफ फैक्ट एंड द लॉ. So, the finality is in relation to points of fact and law which is decided earlier. Ab now this is very important term. Decided earlier means what? तो res judicata में भी बिल्कुल वैसे ही ingredients will see which was there in res subjudice, but the only difference is in res subjudice there was a suit pending between two parties before the same court, but यहाँ पे the earlier previously filed instituted suit, its over, has already been adjourned, has already been decided, and later on we subsequently file another suit. So, giving finality and conclusiveness of the judgment which was already given in the same matter, and thereby we prohibit the subsequent court to entertain the matter between the same party, saying that already the judgment has been issued in the previously filed instituted suit, and hence there is no need of going further, or there is no need of going again in that particular matter, not the word further, but there is no need of going again or looking again back this particular matter. So, finality is in relation to the points of fact and the law which is decided earlier. Next is such a finality act as a bar on every subsequent suit between the same parties. So, this finality or act जो है, जो भी हमारा पॉइंट्स को लेके हम फाइनल फैक्ट्स को लेके एंड लॉ को लेके जो पॉइंट्स हैं हमारे, उन पॉइंट्स के ऊपर जब हम पहुंच गए हैं, फाइनलिटी पे पहुंच गए हैं, we have decided the issue relating to the fact and the issue relating to the law, then in that case we would say हम ऐसे फैक्ट्स को और ऐसे लॉ को वापस से सब्सिक्वेंट सूट में बिटवीन द सेम पार्टीज चैलेंज नहीं करेंगे. तो इस तरीके का जो रूल है बेसिकली जो रिस्ट्रिक्ट करता है या बार करता है पार्टीज को ऐसा करने से, उसे हम रूल ऑफ रेस जुडिकाटा बोलते हैं. It further means that once the matter is finally decided by the competent court, अब यहाँ पे बात आ रही है कॉम्पिटेंट कोर्ट की, तो न सिर्फ फाइनलिटी और कंक्लूसिवनेस ऑफ जजमेंट होना जरूरी है, न सिर्फ पूरे फैक्ट्स और लॉस जो भी पॉइंट है, जिन भी फैक्ट्स को लेके या इश्यूज ऑफ फैक्ट है या इश्यूज ऑफ लॉ है, उनको लेके जो भी पॉइंट है, न सिर्फ वो कवर होना जरूरी है, बल्कि साथ ही साथ और इम्पॉर्टेंट इज ये जो फाइनलिटी ऑफ एक्ट है, ये हर एक सब्सिक्वेंट सूट को ही सिर्फ रोकना जरूरी नहीं है, बल्कि ये सब करते वक्त में वॉट एवर द कोर्ट इज, वो अपने आप में कॉम्पिटेंट होना जरूरी है वेन एवर ही इज डिसाइडिंग अ मैटर। फॉर द रीजन जब हम डिक्री डील कर रहे थे तब हमने ये देखा था कि अगर कोई भी ऑर्डर या डिक्री इनकॉम्पिटेंट कोर्ट के द्वारा पास किया जाता है, देन इन दैट केस वो डिक्री या ऑर्डर जो है वो वैलिड नहीं होगा या ऑपरेशन में नहीं आएगा। इसीलिए अगर रेस जुडिकाटा के भी कंसर्न से हम ऐसा बोलते हैं कि भाई जजमेंट जो है वो फाइनलिटी एंड कंक्लूसिवनेस होना चाहिए, there should be finality so far as the points of fact and the points of law or issue of facts and the issue of law is concerned. The finality act must bar every subsequent suit between the same parties, but again it is important that the particular basically order or the judgment must be given by the competent court, and once it is given by the competent court, then in that case it cannot be reopened in the subsequent litigations. Now, what is the idea behind this particular provision is, if we take into consideration the entire idea about what we studied under the res judicata, some three important things comes in our mind. If there is no such rules, there would be no end to litigations, right? A party, for the purposes of harassing mentally to the other party, what would do would file a n number of litigations against that party, so that once upon a time would come wherein a party would be like, oh no, so many litigations against me. So idea behind is not to create any mental pressure or a mental hurdle against someone, and for this purposes this particular rule has come into existence and has been provided under CPC. If there is no such rules, what would happen? There would be no end to litigation and the parties would be put to constraint trouble, harassment as well as the expenses. So in order to restrain this, in order to not make a party suffer with all these kinds or with all these troubles, harassment or expenses, it is necessary that there should be somewhat a restriction, and that restriction is in the form of a res judicata. Now, let us see how this or from where this rule of res judicata is concept. Now, conception of this res judicata we find in these three maxims. Which maxims? First maxim is nemo debet bis vexeri pro una et edem causa. What does this mean? It means no man should be vexed twice for the same cause. Another is interest republica ad sit finis litium. It means what? It is in the interest of the state that there should be an end to the litigation. Third one is what? Res judicata pro vetiate occipitur. What does this mean? Judicial decision must be accepted as correct. So student, these three maxims. Which maxims? No man should be vexed twice for the same cause. I wish you remember this is what you have studied in the constitution also, and this is what you have studied in your CRPC also. So no man should be vexed twice for the same cause. It is in the interest of the state that there should be an end to the litigation. And third maxim, which says that judicial decision must be accepted as correct. So these are the basically three maxims which we consider to be the conception of res judicata rule is. Next is, what is the object of res judicata? As we have already discussed, that we do not want to have a number of litigation against a particular party and number of litigation for the same cause by the same party for asking the same relief, and hence for the purpose of refraining such type of litigation so that there would not be any mental torture to a particular party, we have we are going through this rule of res judicata. So the object behind the rule of res judicata is, or the doctrine of res judicata is, to give a finality to the judgment of the court, to protect a person from endless proceedings, and third one is to avoid a redetermination of same issues which have already been adjudicated upon. So basically these are the three principles which are behind the object of res judicata, or which are actually the objects of res judicata. So now let us see what are the conditions when section 11 applies. There are certain conditions. Only under the existence of these particular conditions we would say the doctrine of res judicata will apply. Now what are these basically conditions? Let us see one by one. First, there must be two suits, one previously filed and the later the subsequently filed. So there must be two suits, one previously instituted and other subsequently instituted. These suits must be instituted with the identical issues. Both the suits must have identical issues, that is to say, same issues. Next, the suits between same parties. Both the suits must be between same parties under same capacities. Now, under same capacities means what? A suit in which one is a plaintiff should also be a suit in which the should also be a plaintiff in the subsequent suit. So, parties must be litigating under the same title with the same capacity. Now, the former suit must have been heard and finally decided by the court. In the res sub judice, what we have seen that the former suit was pending and the subsequent suit, when filed before the court, the party tells to the court that already a former suit been instituted and is pending before the court and yet not decided, and hence we have restricted or stayed the subsequent suit. But here, the former suit has already been heard and has already been finally decided by the court. And later on, the subsequent suit is filed. So, whenever a subsequent suit is filed, the party is going to tell to the court that already a former suit have been finally heard and decided, and therefore the judgment cannot be reopened for discussion again. Next is the court must be competent to grant relief sought for it in subsequent suit. That is to say, the former court and the subsequent court both are competent to enter into the matter. That is to say, student, filing of the suit cannot be, all the time I keep on saying that filing of the suit cannot be stopped, but yes, entertainment of the suit could be stopped. So, by virtue of exercising the filing of the suit right, the party might have firstly instituted one suit and later on instituted another suit, that is to say, subsequent suit. But it is always a bar upon a court that when already a matter has been decided by a former court, then in that case, and already the judgment has been finally given, decree has been finally passed, then in that case, the judgment or a decree cannot be reopened for the purposes of assessment of the matter again by some another court, by because there is a principle of res judicata which applies over the said situation. Next is proceedings to which the res judicata applies. Now these are basically proceedings over which the res judicata principle applies. Firstly, the civil proceeding. Second, the criminal proceedings. Thirdly, the quasi-judicial proceedings of tribunal. Fourthly, the civil suits. Now, why I am saying civil proceedings and the civil suits to be two different things? For the reason that under civil proceedings, all the proceedings which are there under tribunals, arbitration, and everything are covered under the head civil proceedings, and the civil suit specifically means a civil suit. So, civil proceedings, the criminal proceedings, the quasi judicial proceedings of the tribunal, the civil proceedings, the execution proceedings, the arbitration proceedings, taxation matters, industrial adjudications, writ petitions, and other proceedings, all are these proceedings over which this particular principle of res judicata applies. Now let us see when the plea of res judicata must be raised. कब हमको रेस जुडिकाटा का प्ली रेज करना चाहिए? अब इट मस्ट बी स्पेसिफिकली प्लीडेड, डेफिनेटली इसे हमें प्लीड करना चाहिए, स्पेसिफिकली प्लीड करना चाहिए। और इतना ही नहीं, तो जो भी पार्टी इसको प्ली कर रही है उसको क्या करना है, इसको प्रूफ करना है। सो बर्डन ऑफ प्रूफ इज अपॉन अ पर्सन और इज अपॉन अ पार्टी हु इज रेजिंग अ प्ली। that a particular matter is one over which the principle of res judicata applies. So he have to prove that particular thing, that here the principle of res judicata applies. Now third one is raised at a proper stage of the proceeding. One have to raise this plea only in a proper stage. Suppose if the entire proceedings is over and now only the passing of the judgment is there, then in that case it would be very difficult for the court to take into consideration certain pleadings on the part of the party objecting the same. So whenever a party objecting the same, that is to say, if it is claiming that there is a existence of principle of res judicata or the principle of res judicata applies, then in that case you have to raise that at a proper stage of the proceeding. So what would be the proper stage of proceeding? At as early as possible. It has to be raised as early as possible. Next is opposite party must have a notice of the same. So whenever you are raising an objection, the opposite party must have a notice of the same. You have to tell that the principle of res judicata applies. Whenever you are making whatever the statement before the court, the opposite party need to be made notice of the same. So here also the opposite party must have a notice of the same. Here also the notice means that the opposite party must knew that already a suit has been decided by the former court, and because I have filed a subsequent suit, the other party is raising an objection, and hence here the principles of res judicata applies. That is what he should know. Next, the court to afford such a party a reasonable opportunity of defense. Whenever a party please raise a pleas against the filing saying that there is a application of principle of res judicata, then without giving a reasonable opportunity to the other side, the court would not pass any kind of an order, and therefore it is obligatory upon a court to afford such a party a reasonable opportunity of defense. Now, what are the important points which one must keep in mind is the court cannot suo moto decide the plea of res judicata. In the earlier isme, what we have seen that one have to raise the plea at a proper stage, proper time, specifically. Why these all words been used? For the reason that court suo moto cannot decide that there is a plea of res judicata. For court to decide that there is a plea of res judicata, what is important is there has to be a raised defense in respect to that, and then only this res judicata would be considered, and not without that. So unless it is raised in defense, person should raise this principle of res judicata for the purposes of defense of himself. So court cannot suo moto decide the plea of res judicata unless it is raised in defense. Next is the plea of res judicata may be waived by the party. Suppose if party know that there is a principle of res judicata, but party do not want to raise the same, then in that case, it is at the option of the party that they may raise the plea, that they may waive the plea. Next is who has to prove res judicata. कौन प्रूव करेगा कि res judicata है? जो भी बेसिकली प्ली रेज कर रहा है उसे ही बर्डन ऑफ प्रूफ रहेगा, उसी के ऊपर बर्डन ऑफ प्रूफ रहेगा कि वो बताएगा कि कैसे यहाँ पे प्रिंसिपल ऑफ res judicata अप्लाई होता है. तो बर्डन ऑफ प्रूफ लाइज ऑन द पार्टी विच रेजेस द प्ली. The party has to establish that the matter in issue in subsequent suit was also in issue in an earlier suit which was between the parties. Party have to establish by saying that whatever the issue which is involved in the subsequent suit was also the issue which was actually involved in the earlier suit and which was filed earlier, which was considered to be a former suit but has been finally decided by the court and hence cannot be reopened now. Next is the suit has been finally adjudicated upon by a competent court. Again, it is very important that for the application of res judicata, the suit must have been not only finally adjudicated, but it has to be adjudicated by the competent court to try it. Now, students, this is nothing but a principles of res judicata and certain important things which we must keep it in mind while understanding the concept clearly. But In the coming slides, we would be seeing the distinction between res judicata and res sub judice act as a bar in the future proceeding. So, till for today, I'll